The distinction between the two concepts of public order and law and order has been lucidly explained by the Apex Court in Ashok Kumar vs. Delhi Administration, AIR 1982 SC 1143, wherein the Apex Court has observed that the true distinction between the areas of public order and law and order, being fine and sometimes overlapping, does not lie in the nature or quality of the act, but in the degree and extent of its reach upon society. The Apex Court has further observed that the act by itself is not determinant of its own gravity. It is the potentiality of the act to disturb the even tempo of the life of the community, which makes it prejudicial to the maintenance of public order. If the contravention in its effect is confined only to a few individuals directly involved, as distinct from a wide spectrum of public, it would raise the problem of law and order only. It is the length, magnitude and intensity of the terror wave, unleashed by a particular act or violence creating disorder, that distinguishes it as an act affecting public order from that concerning law and order. On the facts of that case, the Apex Court held that whenever there is an armed hold-up by gangsters in a residential area of the city, and persons are deprived of their belongings at the point of knife or revolver, they become victims of organized crime, and such acts, when enumerated in the grounds of detention, clearly show that the activities of a detainee cover a wide field falling within the ambit of the concept of public order. The Apex Court, to the aforesaid effect, has made observations in Victoria Fernandez vs. Lalmal Soma, AIR 1992 SC 687, wherein, relying on its earlier decisions, including Ashok Kumar vs. Delhi Administration, it was reiterated that while the expression law and order is wider in scope, inasmuch as contravention of law always affects order, public order has a narrower ambit, and public order would be affected by only such contravention, which affects the community and public at large. The distinction between violation of law and order and an act that would constitute disturbing the maintenance of public order had also fallen for consideration of the Apex Court in State of UP vs. Sanjay Pratap Gupta, 2004, 8, SCC 591, wherein the Apex Court, after an extensive survey of authority on the issue, brought out the distinction in fine detail, which reads as under: the true distinction between the areas of law and order and public order lies not merely in the nature or quality of the act, but in the degree and extent of its reach upon society. Acts similar in nature, but committed in different contexts and circumstances, might cause different reactions. In one case it might affect specific individuals only, and therefore touches the problem of law and order only, while in another it might affect public order. The act by itself, therefore, is not determinant of its own gravity. In its quality it may not differ from other similar acts, but in its potentiality, that is, in its impact on society, it may be very different. The two concepts have well-defined contours, it being well established that stray and unorganized crimes of theft and assault are not matters of public order, since they do not tend to affect the even flow of public life. Infractions of law are bound in some measure to lead to disorder, but every infraction of law does not necessarily result in public disorder. Law and order represents the largest scale, within which is the next circle representing public order, and the smallest circle represents the security of state. Law and order comprehends disorders of less gravity than those affecting public order, just as public order comprehends disorders of less gravity than those affecting security of state. The stand that a single act cannot be considered sufficient for holding that public order was affected is clearly without substance. It is not the number of acts that matters. What has to be seen is the effect of the act on the even tempo of life, the extent of its reach upon society and its impact. The issue has also been dealt with in the case of Sant Singh vs. District Magistrate, Varanasi, 2000 Criminal Law Journal 2230, wherein in paragraph 7 of the report, while dealing with the point, the Apex Court has held as under: the two connotations, law and order, and public order, are not the words of magic, but of reality which embrace within its ambit different situations, motives and impact of the particular criminal acts. As a matter of fact, in a long series of cases, these two expressions have come to be interpreted by the Apex Court. The gamut of all the above decisions in short is that the true distinction between the areas of public order and law and order lies not in nature and quality of the act, but in the degree and extent of its reach upon society. Sometimes the distinction between the two concepts of law and order and public order is so fine that it overlaps. Acts similar in nature but committed in different contexts and circumstances might cause different reactions. In one case it might affect specific individuals only and therefore touch the problem of law and order, while in another it might affect public order. The act by itself, therefore, is not determination of its own gravity. It is the potentiality of the act to disturb the even tempo of the community which makes it prejudicial to the maintenance of public order. The scope of expression, acting in any manner prejudicial to the maintenance of public order, as appearing in subsection 2 of Section 3 of the National Security Act, 1980 also came up for consideration of the Apex Court. The Apex Court held that the fallout, the extent and reach of the alleged activities must be of such a nature that they travel beyond the capacity of the ordinary law to deal with the person concerned, or to prevent his subversive activities affecting the community at large, or a large section of the society. It is the degree of disturbance and its impact upon the even tempo of life of the society, or the people of a locality which determines whether the disturbance caused by such activities amounts only to a breach of law and order, or it amounts to a breach of public order. In Amanullah Khan Kuditullah Khan Pathan vs. State of Gujarat, the Apex Court has held that the activities involving extortion, giving threat to public, and assaulting businessmen near their place of work was sufficient to affect the even tempo of life of the society, and in turn amounting to the disturbance of the public order, and not mere disturbance of law and order. While dealing with the question as to whether one solitary instance can be the basis of an order of detention, the Apex Court in Bimla Rani vs. Union of India observed that the question is whether the incident had prejudicially affected the public order. In other words, whether it affected the even tempo of the life of the community. In Alijan Mia vs. District Magistrate Dhanbad, it was held that even one incident may be sufficient to satisfy the detaining authority in this regard, depending upon the nature of the incident. Similar view has been expressed in the host of other decisions. The question was answered more appropriately and with all clarity in the case of Attorney General of India vs. Amritlal Prajivandas, AIR 1994 SC 2179, wherein the Apex Court ruled that it is beyond dispute that the order of detention can be passed on the basis of a single act. The test is whether the act is such that it gives rise to an inference that the person would continue to indulge in similar prejudicial activities. It cannot be said as a principle that one single act cannot be constituted the basis for detention. Now the law, as it stands, is that even one solitary incident may give rise to the disturbance of public order. It is not the multiplicity but the fallout of various criminal acts. Though there is consistency in the various decisions of the Apex Court about the interpretation of the expressions of law and order and public order, undue insistence on the case law is not going to pay any dividend as each case revolves round its own peculiar facts and has to be viewed in the light of the various attending factors.